This is file number 222359FY, People versus Jack McEntee. The third. Jack the second is also here. He was charged with some very serious offenses. The matter was resolved with a plea to a misdemeanor charge of criminal sexual conduct, attempted fourth degree, and a domestic violence first offense, 2 counts. He was placed on probation after a period of jail. Of 64 days. I hung 126 days over his head, put him on a lengthy probation and fines and costs.
Correction, Your Honor. He served the full 180 at the time of his sentence. The court gave him 6 months, and he had credit for 64, so he had 120 left to do or so.
Let me look. Well, I thought that's what I said. Oh, darn it. Let's get that straight. Yes, 180 days, credit 64, then he did 126, and then the other portion was remaining. His probation agent, Autumn Kiefer, has filed a probation violation petition alleging that he has violated his probation. It's alleged that he failed to abstain from the use of alcohol and drugs, failed to test on demand. Article 9, that he failed to participate in treatment. That was set for a hearing on June 7th for the arraignment. Defendant pled not guilty, and the matter was set for a probation violation hearing. I think it got adjourned for some reason. And the matter was set for today. In the meantime, I think some things have happened regarding the DV class and other info. Autumn provided an updated status report dated July 20th of 2023. It is alleged that he was arrested with a PBT of 0.021 on May 14th, released on May 15th. He had also allegedly consumed alcohol earlier in May. He had also sought to get his Adderall prescription refilled, which has been an ongoing problem. It's also alleged that he violated the condition regarding treatment, and he did not keep his appointment with the substance abuse assessment. And frankly, I'm not sure what the status of the domestic violence class. Here's what Autumn says. He asked if he could just sit and be done with the probation. Mr. McEntee has no desire to serve any probation, and she's concerned about his mental health and his addiction. Mr. McEntee needs serious inpatient rehab for his mental health and addiction issues. He is staying in contact with the probation officer. It doesn't seem stable. He doesn't have any money and pay for the testing. She's afraid he's using Adderall again. And Keystone was paying for a place at the Country Hearth Hotel, and that's not an ideal situation. And he has still not found employment. Autumn recommended 126 days of reserved jail time, but as Mr. Mayval printed out, those days I don't think were reserved. I think he did them. I'm not asking yet whether he admits or denies the violation, but Mr. Mayval, what's our status here? I don't have the benefit of the probation agent or the prosecutor.
Your Honor, I'm quite certain that Mr. McEntee was prepared to admit to at least what I believe to be the thrust of the allegations, that he'd had the positive alcohol test and not followed through with the substance abuse evaluation that had been scheduled. When he contacted me, we did seek to reschedule that.
Well, let me ask that, Jack, is that your intention to simply admit the probation violation?
To admit?
Yeah, that you drank alcohol and you didn't follow through on your alcohol counseling?
Yeah. Yes, sir.
Anybody threaten you to get you to do that?
No.
Or promise you anything? And you realize you're entitled to have a hearing on that if you wish. You've retained counsel, which is good because he's got the whole picture here. He's been in this since the beginning. And he knows you, he knows the facts, he knows the case. So I'm pleased that he's here. But that was at your expense. So we could also have appointed an attorney for you. But however, at this point, you acknowledge that you drank alcohol on a couple of occasions in May. And you didn't follow through with your substance abuse assessment. You admit that?
Yes, Your Honor.
What is the status of the domestic violence treatment class?
I attended class this past Tuesday,
How many sessions have you been to?
about 8.
Well, there's a plus there. Where are you doing them?
Like WebEx, Zoom meeting. Via Calhoun County Services through KPEP.
All right, he's admitted the violation. I'll accept the admission. Question is, what do we do now? And Autumn's not here. I wish she was. She's got some health issues in her family that she's dealing with. They're certainly trump everything else. But Mr. Mayval, what's your thought here?
Your Honor, I'm asking for Mr. McEntee to be unsuccessfully discharged from probation. Mr. McEntee was levied a pretty significant punishment at the time that he entered a plea in this case. These were allegations involving an ex-girlfriend that had taken place years earlier, and Mr. McEntee had sat in jail for 60 days. And prior to his examination, he entered into a plea deal that he knew would subject himself to additional jail time, statutory probation, and the most significant consequence, which was going to be the requirement that he register as a sex offender for the next 15 years. Additionally, Mr. McEntee admitted to 2 separate misdemeanor domestic violence offenses, which were somewhat token in nature at the time, but it offered adequate assurances to the prosecutor and to the community that if Mr. McEntee was to ever be alleged to have laid his hands on a domestic partner in the future, that he would be facing felony prosecution for that. Between the jail time, having to hire an attorney, having to come to court, doing the jail sentence, facing the term of registration, knowing that he's on a short leash and can't ever get in trouble for something like this ever again, the prosecutor's office and the probation department had felt like they'd gotten their pound of flesh, and it was them that knew more than anyone the nature of the allegations against him. I pulled his pre-sentence report from the time of his initial plea and sentencing, and I have a copy of that here, Your Honor, but I'll just reference the recommendation of Ms. Kiefer at that time. It was a recommendation for 93 days in jail with credit for 64 days, leaving 29 days left to serve with no probation. I appeared with Mr. McEntee in custody at that time, and Your Honor, very appropriately so, was not satisfied with that sanction in terms of adequate punishment. And the court did not go along with the jail recommendation nor the recommendation for probation, but instead gave him the 6 months in jail and required him to begin probation with the department. They didn't want him from the start, and that's not to say that he's done everything that's expected of him. But we knew going in that Mr. McEntee was going to present a couple of logistic challenges. During his time in jail, he'd lost his job, he'd lost his car, he did not have stable housing lined up, but he was certainly as clean as I'd ever seen him. When he was getting ready to be released from jail, I was confident that Mr. McEntee was excited about getting work lined up and putting this behind him. The prospect of putting it behind him with a 5-year probation term in front of you with an officer that didn't want you in the first place has proved to be a position of stress for him. I asked him when we went over the probation, the updated report, if everything in there was true and accurate. And the only correction that he had was he said that he didn't tell her that he wanted to serve out the rest of his time. It was on a day where he was frustrated with what was being expected of him. And he asked what his options were. He'd asked if it was an option to go before the court, like what happens if I don't do everything that's expected of me. And so I wanted to at least clarify his position that he certainly never expressed a desire to Ms. Kiefer that he would rather sit in jail than be on probation. I don't think that was the case. In light of the fact that he did twice as much jail time that was being initially recommended, it strikes me as odd that Ms. Kiefer would then later come back and suggest that he deserves quadruple the time that she'd initially stated because he blew a .02 into a PBT.
Yeah, it was quite, I think that I was concerned about the Adderall and concerned about the not getting the substance abuse assessment, but I'm very pleased he's doing the domestic violence. And the recommendation is incorrect because it recommends the 126 days that were deferred, but they weren't deferred. He did 126 days. So he did 180 days at my order, which was about twice what she had originally recommended. And she's been off because of this family medical problem. So I haven't had a chance to discuss this with her. She's been gone for about 2.5 weeks. And Ms. Davis, I know that you were aware of this circumstance and the plea agreement. Mr. McEntee was a young man full of such promise. And I'm not saying he isn't anymore, but he was a handsome young college athlete, bright guy, and Adderall and some other things, mental health issues have derailed him. When I talked to you the last time in June, you had an orientation at Walmart where you were going to start the next day. What happened to that?
I don't know. Like, I didn't really receive. I accepted the offer, and they haven't like invited me for orientation. So I just was assuming like it was aligned with like charges that I have on my record.
They never, because you were going to go in like the next day.
Yeah.
Did you go in the next day?
I didn't get like a orientation date.
And which Walmart was it? One of the ones in Kalamazoo?
On Shaker Road.
All right. Yeah, this doesn't help your employment prospects when you've got this baggage. Deborah, what's your thought?
Your Honor, this plea agreement was discussed with our victim with the idea that Mr. McEntee has some pretty significant issues with use of his medication improperly and anger and all of the things that alcohol included. Part of the comfort level for the victim was that he was going to be on a 5-year probation. Probations aren't terribly difficult. Don't drink, don't use drugs like you're not supposed to and not prescribed, report like you're supposed to. It's not difficult. And to be able to say to the victim, hey, he's gonna have a 5-year probation, it could get cut short if he does good. That was comforting to her because it meant there was going to be oversight, there was going to be drug testing, there was going to be somebody that he has to check in with. And if he doesn't, there is the option for additional jail time the rest of the year that remains. And so I feel like the defendant has kind of done what he wanted to do and didn't care because he thought, well, worst case, I'll get a little bit more jail and I won't have a probation anymore hanging over my head for the next 4.5 years. I don't think he really gave it an honest effort at the probation. And again, I think it's somewhat disingenuous for him to come in and be like, well, I'll just serve a little more jail, or hey, maybe I served enough jail already and I don't need to be on probation. There's a reason why there are 5-year probations for sex offenses. That bit of comfort to the victim of having that oversight, not just that he's on the sex offender registry, because that does nothing for the victim as far as having some punishment for them if they were to drink or use or whatever. The sex offender registry is more to notify people, and if he doesn't register his address, he could get in trouble. But the probation piece of it, I think, was what gave her some sort of sense of peace. And so I would ask that if he's not going to be continued on the probation, that he serves the remainder of the max jail.
I think that's what he's prepared to do. Ultimately, the court only has jurisdiction up to the statutory maximum of the offense, which in this case in the DVs is 93 days, and in the CSC attempt 1 year. I am encouraged that at least he's done 8. How many sessions are there in your program?
It's 26 weeks, and I've done about 7 or 8. Calhoun County Services through KPAP. It's a class with like 6, probably like 4 or 5 guys. It's via like WebEx.
I understand that you don't want to be on probation, and it was quite an onerous sentence to put somebody in district court on 5 years probation. As Trevor Mayval, your lawyer, indicated, your blood alcohol was 0.02, not 0.2, but you'd had some alcohol. My other concern is that you went to Adrian and got a prescription for Adderall, which is the source of much of your problems. Is that prescription run out?
Yeah.
So you used it and that was the end of it?
Yes, sir.
Um,
I believe the rest of it, the jail has it, but I don't have it.
Occasionally in drinking driving cases, I've given the defendant the choice of some jail time or a probation. Very often they'll just choose the jail time. This is only on the attempt CSC charge. The domestic violence, you've already served more than the statutory maximum. I don't know how, as I said, I've known you since you were a high school athlete. I've known your dad for 50 years. And there's a phenomenon that happens sometimes in young men that mental illness kicks in your late teens or early 20s. And it disrupts the rest of your life. We've seen several people. One of our young attorneys just passed away, and he developed schizophrenia in his 20s, and it went from a life of promise, law school, college, valedictorian, to schizophrenic. You don't choose it. So I can't tell how much of this is mental illness, how much is Adderall, how much is stubbornness. I don't know. Anyway, the complainant was quite upset, and it was charged as a criminal sexual conduct first degree. And we didn't have a trial. You allowed this agreement with a plea. But as Mr. Mayval indicated, it went from 0 to 60. But he doesn't want to face his substance abuse issues or his mental health issues, but he was dealing with the domestic violence issues. My only regret is we won't continue that class. Probation is revoked. I'm going to order 300 days credit 127.
180.
181, excuse me. Which is $119 days. There will be good time calculated into that, which means about 100 days. If you're a trustee, you'll be out sooner than that. There's nothing else I can do. I am giving some credit for the domestic violence cases that you did complete. This makes me sad because I don't know that it's a good answer, but I'm going to get off your back. You can move to Hawaii. You can go to Acapulco. You can become a movie star without having to report to me or Autumn or anybody else. But you will be still stuck with the registration stuff. So you're willing to take your lumps. I've reduced it. You'll get good time. And Jack, I wish you the best, but that concludes this. All right, you're good to go.